year process that finally came to fruition. And then Russ came in the Senate after I did, but almost immediately was in leadership because of his character. So glad to have worked with these guys. Now the Supreme Court race is a nonpartisan race, but it is one of the most important races you're going to have on your ballot to protect your individual liberty. And I'll tell you why, and I'll give you some examples that we see at the federal court level. You know, when we were deciding what kind of constitution we would have as a country, you know, the Federalists and the Anti-Federalists debated. The Federalists 51, Madison wrote, the most important protections of your liberty as an individual are the two separations of power, the separation between the branches and federalism. And those are two things that we have seen completely lost at the federal level. And I'll give you a couple of examples that are going to be going on right now. But it's the most fundamental duty of a justice to apply the Constitution as it's written and give the words the meanings they had when it was ratified.
Okay.
So the policy is set by the people either through the legislature or through the amending process. You know, as Cliff said, we've got HJR 5 on the ballot, but we as a state, we've amended our Constitution 130 times. Usually it's maybe you may not think it was a significant policy issue like HJR 5 is, which I think is an important one. But it's something that we have a process to do. And it's really been only since the 1960s that the U.S. Supreme Court has started to amend the Constitution through what they call substantive due process. That's under the 14th Amendment, which protects due process under law. And they've taken the word liberty in that amendment and applied it to a whole new range of things. First it was contraceptives in the 60s, then in 1973 it was the issue of abortion. Since then they applied it to sex acts and now marriage. You know, Justice Scalia said the due process clause is a procedural due process. It protects procedure and it protects those fundamental rights that were recognized at the time it was passed. And if the people want to set new policies, they can do that. They can do that through the amending process. And so we see the court drifting more into that area. And on the other side, we see the executive branch doing it as well. And the example that we see right now that's going to come up through the courts is where the federal government is suing the state of North Carolina over who can use the bathrooms. The limitations the state can put on as to who can use what bathroom. And they're doing it under a 1964 statute, the Civil Rights Act of 1964, and Title IX of that, which most of us know because of sports at the collegiate level that requires equality between male and female sports. But they're applying it now to an issue that was never considered by Congress when they passed the statute. And so unelected bureaucrats in the Department of Justice have redefined what the legislature meant in that statute. And it's going to come up through the court system to the U.S. Supreme Court, and you'll be able to tell pretty quickly what the philosophy of the next justice is on how they treat that extension of power by the executive branch. So on constitutional issues, it's important, but I say it's equally important on issues like water rights, on your contract rights, or any other rights, that a justice apply the language of what's there. Because under the rule of law, you should have predictability when you go into court. That's the most important thing to an individual, to a business, to a party in a lawsuit, is that the law or contract or whatever they're there for is going to be applied according to its plain language. And a justice may not like the particular agenda or policy that's set by that, but it's not their place to change that. That's left to the legislature or the parties. And so